Resuming debate, reprise de débat. The honourable member for Mount Royal.
Thank you, Mr. Speaker. I rise today as well to address amendments to Bill C-279, an act that amends the Canadian Human Rights Act and the Criminal Code to protect transgender Canadians. In its original form, it did this by adding gender identity and gender expression to both statutes. As I stated the last time the bill was in the House, I support this important effort, which will have not only symbolic but substantive and practical effects to provide human rights protections to a group that, for example, the Ontario Human Rights Commission has characterized as, quote, as disadvantaged and disenfranchised as any in our society today. We are presented now with the unusual yet welcomed opportunity to reconsider amendments to C-279 that were raised at committee. These amendments, which remove gender expression and add an agreed-upon definition of gender identity, were the product of a compromise solution, agreed to maintain the support of the 15 Conservatives who joined with the opposition and voted for the bill at second reading. While I had hoped that both gender identity and gender expression would remain included in the bill, I appreciate the need for compromise in order to make progress on this critical issue. On that note, I would like to commend the sponsor of this legislation, the member for Esquimalt, Juan de Fuca, for the spirit of cooperation he has maintained throughout this process. With respect to the amendments that add a definition of gender identity, I welcome the fact that the chosen definition makes explicit reference to the internationally recognized Yogyakarta principles. While these principles are not themselves binding international law, they were developed by some of the world's foremost experts on international human rights law and are intended to serve as an interpretive aid to human rights treaties. As an international law scholar myself, I am always pleased to see us referencing elements of internationally recognized principles in our own domestic legislation. As I mentioned with respect to the exclusion of gender expression, it was initially my preference that both terms remain in the bill. Again, I am cognizant of the possibility that even in the absence of gender expression, the term gender identity might, through case law and through an appreciation of the travaux préparatoires, eventually come to encompass part or all of that which would have been protected by the former. All things considered, the amendments in question today are as reasonable as those given that Parliament would still be taking a significant step forward with respect to protecting the rights of transgendered Canadians. As of now, these individuals can only exercise their rights under the Canadian Human Rights Act by advancing a claim under the prohibited grounds of sex and or disability, as the Parliamentary Secretary himself acknowledged. To be clear, tribunals do hear the cases of transgendered Canadians, but such claims thereby are complex, costly, and rely on grounds such as in the case of disability that may themselves be highly offensive to the claimants themselves. Some might ask why this is necessary legislation if transgendered individuals already benefit from such protections, which is basically the query put forward and complaint put forward by the Parliamentary Secretary. Besides the symbolic value of recognizing this group in statute, C-279 produces three substantive and practical effects of note. First, the Canadian Human Rights Commission would begin keeping statistics on incidences of discrimination targeting transgendered individuals. Second, the Commission would begin raising awareness about transgender issues in its communications. And third, public officials would begin receiving briefings and training on the matter. This is, of course, in addition to the most important change offered by this bill, the offer of a clear and explicit human rights recourse to transgendered Canadians, not only in that it provides an express protection for transgendered people, but it provides an effective remedy. And this is something that cannot be marginalized or ignored. Mr. Speaker, there is precedent for the use of the term gender identity in Canadian provincial as well as international context. Notably, in the United Nations Declaration on Sexual Orientation and Gender Identity, which Canada signed in 2008, as well as what I mentioned earlier, the internationally recognized Yogyakarta Principles. In a word, I believe that this legislation would better ensure that transgendered Canadians enjoy the same equality of opportunity and freedom from discrimination as all other Canadians, as the member for Esquimalt Fuka has so aptly affirmed and demonstrated in his remarks and in his work throughout this process. However, it bears pointing out that we are in this rare situation today of reconsidering amendments because a minority of Conservatives on the Justice Committee engaged in a concerted and regrettable effort to thwart debate at a clause-by-clause stage. Indeed, the intention was clearly either to obfuscate the subject and spirit of the bill, or if nothing else, to torpedo the compromise arranged by the mover. To start, they came with their own amendments, including a handful that only reinforced the status quo formula of sex and disability. Then a frivolous amendment exempting official Canadian sports authorities from the provisions of the bill, as if to contain some fictional mass of men trying to compete in women's sports and vice versa. And finally, an out-of-context amendment that sought to ensure that no part of the Canadian Human Rights Act can infringe upon the rights of Aboriginal people. While I firmly believe that we should only enact legislation that is indeed mindful of the rights of Canada's Aboriginal peoples, I found there was no reason to codify this specific protection into the Act, for the Charter supersedes any statutory act as clearly set forth in Section 52 of the Constitution Act, and it appeared this too as a diversionary item. Despite the tactics of diversion and delay, the compromise still could have been implemented at committee. With the support of one of the 15 Conservatives who voted for the bill at second reading, who we should credit for their open-mindedness, the committee accepted the amendment we are reconsidering today to remove gender expression, rendering several other Conservative alternatives inadmissible. Unfortunately, this procedural oversight by the Conservatives opposed to the bill spurred them to engage in a filibuster, behaviour which the Speaker has obviously himself acknowledged given his decision today. Now, hopefully, we can conclude the amendment process with an honest debate on the merits. Mr. Speaker, I would like to once again remind members of what is at stake with regards to this bill. To quote Mr. Justice Laforêt of the Supreme Court of Canada at the time, gender identity must be included as a protected ground in the Canadian Human Rights Act, because, quote, to leave the law as it stands would fail to acknowledge the situation of transgendered individuals and allow the issue to remain invisible. We also ought not to disregard the history associated with this legislation, which has been introduced 7 times since 2005 and was most notably passed by the House in early 2011, only to die on the Senate floor following the dissolution of Parliament that same year. Today, I urge my colleagues to not let be another failed attempt at establishing equality and fairness for transgendered Canadians. The time to act is now. Thank you, Mr. Speaker.